It is the discretionary power of the court to determine the amount of maintenance under the Hindu Marriage Act 1955, Hindu Adoptions and Maintenance Act 1956 and Code of Criminal Procedure 1973. The court has the preferable discretion to decide whether to grant maintenance or not. If it decides to grant it in the favor of the claimant, then again in its discretion to decide what amount of maintenance will be granted. However, while doing so, the provisions mentioned under Section 23 of the Hindu Adoptions and Maintenance Act 1956 will be followed, which has prescribed grounds for the court to be taken care of while deciding the question of amount of maintenance for wife, children and aged or infirm parents. The grounds mentioned are as under. Number 1. Position and status of the parties. The court shall take into consideration the position of the respondent against whom the order of maintenance is to be made. The means and capacity of such person shall be the guiding values while determining the quantum of maintenance. Not only his or her actual income from all sources, salary, if any, expenses, social and economic status shall be considered, but also the potential earning capacity will be taken into consideration. Number 2. Reasonable wants of the claimant. The claimant should mention his or her wants very reasonably. The purpose for awarding maintenance is to provide such claimant the basic needs for life. Therefore, it will be highly unreasonable on his or her part if demands are made for luxurious lifestyle. Only reasonable wants will be taken into consideration of such claimant while determining the question of amount of maintenance. Number 3. Separate residence and maintenance. Section 18, subsection 2 of the Hindu Adoptions and Maintenance Act 1956 provides the right to a wife to separate residence and maintenance. Even a child who left his parents will not lose his right to maintenance, though the amount of maintenance shall be decreased accordingly. The court will consider the justification of the claimant for living separately. Number 4. Value of the claimant's property and income. The position and status of the claimant will also be considered while awarding the quantum of maintenance. If such person is employed and has a good income, the amount will be decreased accordingly. If claimant earns more than the respondent, then it will be prejudicial to award a larger amount of maintenance or to award it at all. Number 5. Number of persons entitled to maintenance. In case of number of persons entitled to maintenance, the court shall look into the fact of numbers of such persons. With the increase in number of persons, the value of all the claimants shall be adjusted accordingly. The ground will be taken into consideration where a person is under obligation to maintain wife, children as well as parents at the same time. In addition to the above grounds, if the claimants are dependents, then in accordance with subsection 3, the following grounds shall also be taken into consideration. Number 1. Prior payment of debts. The maintenance provision should be made only after the payment of debts of the deceased. The provision is equally echoed with the provision of Section 26 of the Hindu Adoptions and Maintenance Act 1956. Number 2. Provision made under any will. A provision under a will of the deceased made before his or her death will be fulfilled before setting the amount of maintenance. Number 3. Degree of relationship between the two. The remoter the degree, more decrease will be there in the amount of maintenance. Number 4. Past relations between the dependent and the deceased. The court will also look into the past relation between the dependent and the deceased. While passing an order of maintenance under Section 25 of the Hindu Marriage Act 1955, the court will additionally consider the conduct of the parties and other circumstances of the case and may secure the payment by creating a charge on the immovable property of the respondent, and under Section 26, it will also consider the wishes of children. but no charge can be created unless by way of will of the deceased, by a decree of the court, by agreement between the dependent and the owner of the estate, or portion or otherwise in case of maintenance claim of dependent as given under Section 27 of the Hindu Adoptions and Maintenance Act 1956.